What do you think the 60-day pre-suit notice is? Is everybody familiar? Raise your hand if you're familiar with the 60-day pre-suit notice. Okay, in many states, and I think almost all of them now,
About three-quarters, yeah.
about 3/4 of the states, before Sean, the attorney, can actually file a lawsuit, he has to give a 60-day notice to the insurance company of his intent to do so. Do you know what he does in that 60 days? He does the duties after a loss for the first time for the insured. They have never been done. So when he does the duties after a loss for the insured, it's an attorney doing them. It's not a public adjuster, it's not the insured, it's an actual attorney. So who does the other side have involved? They have their attorney, don't they? See, the crazy thing is what often happens is that when this attorney reads the contract for the first time for anybody on the insured's behalf, he goes directly to the duties after a loss, he performs them as an attorney, not as a public adjuster. He has to get them done because he has to bring the insured into compliance before he can file the lawsuit. So he goes and gets this done for the first time, sits down with a opposing counsel, and opposing counsel looks at it and says, well, dadgum, this is the first time we, as the insurance company, have seen full performance of this contract. Thank you for doing that, Sean. And they may agree with the estimates and everything that Sean provided, and they may resolve this claim right here. This is not a crazy thing, correct?
Yeah.
Okay, so what actually happened? The attorneys became very high-priced adjusters. That's all they did was they adjusted the claim for the very first time. And when they did, and then the insurance company attorney says, I have a contract in front of me. That contract requires the insured to do ABC. Mr. Hodge, being the attorney, did ABC. We agree on the damages, and I'm paying this claim at the value that he paid right there. Who's going to pay Mr. Hodge? The insured is, aren't they?
Why can't they bypass the 60 days if all the A, B, and C was done by the PA?
Because it's law.
It's reasonable.
It's still gotta wait.
No, it's law. You don't get a choice.
Statutory.
Yeah. Yeah, it's straight up. You don't, and if
I mean,
you
I knew it was
do,
a law, I didn't know there was a
Would
reason.
you-
well, let me say you can,
You
but then the
can?
claim will be thrown out completely and you'll be barred from refiling.
So some states, it can be thrown out. Some states, you can lose a lot of your damages. Meaning, if you didn't send the 60-day pre-suit demand, you can't collect attorney's fees as damages. You can't collect bad faith. You can't. So you're limited on what your recovery could be if you try to even file it day 59, right? If you file it one day early, you cut off some of your damages. Sometimes it's very severe, the damages you cut off.
But why would you want to if it's the law?
No, I didn't, I was just asking, I knew it was the law. I was thinking any type of incentivizing.
Is there a
public
way to do
adjusters
it?
Now, if you've been to camp, and you have, what you're doing is you're making Sean, you're allowing Sean to do what he does, and that's to bring the law to it. He doesn't have to become an adjuster. He simply has to verify that what you've done is correct. He has to send his own people. All of that has to occur. But it's not to do the case for the first time. It's to prove or disprove what you have done. Whoever sent the file to him that did their job and said the insurance company has committed bad faith, Mr. Hodge, it's now time for you to bring the law to it. He now has to verify it so that he doesn't get in trouble, and then to build the case, to strengthen the case. But it's not him doing it. It's him verifying, which is a totally different thing. If it was done before he gets it, then all of those fees are on the table. Mr. Insurance Company, the contract was done prior to my involvement. You had every opportunity under the color of law to go out and do what you were supposed to do, and you did not do it. I'm speeding, you're breaking the law, we're both going to get our day in court. Right? At this point, Sean's attorney's fees become a negotiation tactic. Right? They're not going to take this to court. Why? Because they're going to get their ass kicked. So they're going to offer the insured a number that is close enough to them to make them whole, knowing they're remember they're risk managers, right? They know these numbers down to a T. They know me, they know you, they know everything more than what we think we know about ourselves. So when the number comes, they're going to offer Sean and tell Sean, here's X number. Right? That number wasn't a random number. That number was a multiplier. It took every known factor that they had, they put it together, and the AI machine spit it out and said, if you put this number out there, Sean doesn't have a choice. He has to go to the insured, notify the insured of what that settlement offer was, and then the insured does the math. You mean I get that money today? That's number one. And then number two, who pays the attorney? Well, they're not paying the attorney, but here's the settlement number, and you wanted $100,000.